In what many would call a high risk legal maneuver, Special Prosecutor Jack Smith has asked the Supreme Court to rule directly on the question of whether or not former President Donald Trump can be prosecuted in regard to his actions on January 6, 2021. It's not so much that Smith is asking the Supreme Court to do this that's so unusual. It's the fact that he's asking the Supreme Court to bypass a current appeal that is before the appellate court. What's going on and why is he doing this? Hang on, folks. We're going to get into all this in just 1 second.
My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk.
Today, a motion was filed before the United States Supreme Court that many people are questioning the wisdom of, the timing, and whether there's any politics behind what's going on. Special Prosecutor Jack Smith, who we here on the Electronic Front Porch affectionately refer to as Jackboot, filed a motion with the United States Supreme Court asking that they grant a petition of certiorari for the purpose of hearing the case of whether or not Donald Trump is immune from prosecution related to actions taken on January 6th, or, if he is not, that a trial can proceed beginning on March 4th of 2024, which just happens to be one day before the Super Tuesday primary. But we'll lay that question aside for just a second. So let's take a look at what's going on and look at some of the arguments surrounding this whole thing. We go to the Epoch Times. Headline: Special counsel asks SCOTUS to rule on Trump's presidential immunity defense. The prosecutors are holding fast to a March 4th, 2024 trial date, the day before the Super Tuesday primary elections. Trump described it as a Hail Mary effort. Article written by Catherine Yang, we read the following. The special counsel's office is preempting former President Donald Trump's appeal of his case to the U.S. Supreme Court by petitioning the High Court for a writ of certiorari before judgment, an immediate ruling on whether the former president can rely on his presidential immunity defense. Special counsel Jack Smith has charged President Trump on 4 counts regarding his actions to challenge the 2020 election results. President Trump has filed 4 motions to dismiss the case. Several were rejected by U.S. District Judge Tanya Shutkin, and the defense has since appealed the motion to dismiss based on presidential immunity to a federal appeals court. The prosecutors are asking the Supreme Court whether a former president is absolutely immune from federal prosecution for crimes committed while in office or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. President Trump had asked the district court to pause proceedings pending appeal, noting that he would seek that pause from the appeals court if the district court didn't grant it. If granted in either court, the legal strategy would certainly throw off the trial schedule. Prosecutors are now asking the Supreme Court to issue judgment before the appeals court makes a decision. Quote, this court presents a fundamental question at the heart of our democracy, the special counsel's team argued in the new filing. The district court rejected respondents' claims, correctly recognizing that former presidents are not above the law and are accountable for their violations of federal criminal law while in office. They argue that President Trump's legal strategy in the appellate court now jeopardizes the March 4th trial date. Quote, it is of imperative public importance that the respondents' claims of immunity be resolved by this court and that the respondent's trial proceed as promptly as possible if his claim of immunity is rejected. They claimed that President Trump is, quote, profoundly mistaken on the law, and only the Supreme Court can definitively resolve the issues at hand. The courts granting the writ of certiorari before judgment would, quote, provide the expeditious resolution that this case warrants. Okay, let's get into this. By way of a little bit of background, This has now been going on for quite some time and is now about to reach its culmination. In other words, a potential trial to start on March 4th, 2024, which, as mentioned by both the Epoch Times and yours truly, happens to be the day before the beginnings of the Super Tuesday primary. But laying aside my, shall we say, suspicious nature, let's analyze this for just a second. The president, or former president in this case, has made a motion saying, look, I'm exempt from this under presidential immunity. The actions that I took on January 6th are covered by my office. I was president at the time. I was acting as such. Smith claims, no, that's not the case. Trump asked for a dismissal of the charges. Judge refused. Trump and his legal team did what you would expect them to do. They appealed it up to the appellate court. Now, the appellate court has not scheduled a date to hear the appeal. They have not asked for filings from both sides. In other words, this is going through the normal legal process that you would otherwise expect. The problem is, Smith's not going to tolerate that, or more to the point, it seems he does not want to tolerate that and has gone over the appeals court directly to the United States Supreme Court and asked them to rule on this. Now, does Smith have the right to do that? Yeah, he can do it. But it sort of begs the question, why? And unto what motivations are causing him to make this to want to happen? Now, some people are going to hear what I have to say next and say, oh, well, here's the Trump supporter standing up, for his guy in the election. No, okay, I will concede up front, yes, I am supporting Donald Trump for the presidency. But laying aside my political support for the man, he is one thing above all else, whether you like him, don't like him. That's up to you. But he is one thing above all else. He is a citizen of the United States who is guaranteed certain rights under the United States Constitution and its Bill of Rights. He just also happens to be a former president of the United States, which makes his actions a little bit different than the average citizen. Now, what does all this mean? And there are some perfectly legitimate questions that ought to be asked, and some people have taken to Twitter to ask those questions. And I'll start with the inestimable Byron York of the Washington Examiner. On his Twitter page, he asks the following. Did I miss something? In SCOTUS's request, Jack Smith repeatedly says it's super important Trump immunity issue be decided quickly, but he doesn't say why it must be decided quickly. Obviously, that is so Trump can be tried, convicted, and sentenced before the 2024 election. Why not explicitly say so? Okay, let's lay aside the latter half of what Byron York puts in there. That's his opinion, which, by the way, we'll get to my opinion on the whole matter here in just a minute. But he does ask a very important question. Why does this have to be resolved so quickly? Why not just let this play out before the appeals court, and if they don't rule in favor of Trump, one side or the other, depending on who wins the motion at the appeals court, can at that point take it up to the Supreme Court if they wish. It seems like Smith is rushing this thing. Well, let's go directly to the document that Smith and his team filed to the U.S. Supreme Court. I want to show you something, and I think this is worth pointing out. This starts on page 15, and I'm going to read this paragraph in its entirety. The district court presiding over this case rejected respondents' constitutional arguments and has scheduled the trial for March 4, 2024. Respondents' notice of appeal, however, suspends trial proceedings. See Griggs versus Provident Consumer Discount Company, 459 U.S. 56, 58, 1982, per curiam. And respondent has moved for a stay of all proceedings in the district court while his appeal is pending. See District Court Doc 178. It is of paramount public importance that respondents' claims of immunity be resolved as expeditiously as possible, and, if the respondent is not immune, that he receive a fair and speedy trial on these proceedings. The public, respondent, and the government are entitled to nothing less. Yet if this case proceeds through the ordinary and even a highly expedited appellate process, it is unclear whether this court would be able to hear and resolve the threshold immunity issues during its current term. For that reason, the government seeks a writ of certiorari before judgment to afford this court an opportunity to grant review now and ensure that can timely resolve the important immunity question presented here. Now, I want to go back to something that we just read, and I want to repeat this, and I'm doing it for emphasis, and you'll understand why here in just a second. The public, the respondent, and the government are entitled to nothing less. In other words, a fair and speedy trial. Well, I'm no lawyer, and I'm no expert on the Constitution. I don't claim to be either one, but there is something that I do remember in the Bill of Rights, Jack. If you happen to be listening to this, I strongly suggest you go back and reread the Sixth Amendment, where it says the following: in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Pardon me, Jack, but I don't remember that saying anything about the government being entitled to a speedy trial. Just the defendant. Yet, if you read very carefully what Smith is arguing, the defendant and the government are entitled to a speedy trial. No, sir. The only person entitled to a speedy and fair trial is the defendant, the accused, which in this case is Donald Trump. Now, I would like to also point out some other things in case people have forgotten. The judge ruled almost within 7 months of the time they got a hold of this. Well, let me back it up, rephrase it differently. If you take the start date of the trial and back up to when the judge set the date, that's a period of 7 months. Furthermore, the defense, Trump's lawyers, have to review anywhere from 12 to 13 million individual documents related to Trump's defense for January 6th. Now think about that for a second. 12 to 13 million individual documents, and you basically have 7 months to do it in. I don't care how big a team of lawyers you've got. There is no way in the infernal regions of Dante's hell that you could possibly get through that many documents and prepare an adequate and fair defense of your client in the time frame that Judge Shutkin is allowing. So, yes, the defendant has a right to a speedy trial. The defendant does not have the obligation to let him or herself be railroaded, which I get the distinct impression Shutkin's trying to do at the behest of Jackboot. But let us go on. There are others who have opined on this whole situation. Julie Kelly. And this I would like to read. Judge Shutkin, appointed by Obama, fast-tracked this trial, aware of all the litigation that would be involved beforehand. Rather than a year or more between indictment and trial, the normal time frame for January 6 trials, she set a 7-month window. Now, she and Jack Smith are throwing the political and legal system into chaos, and they don't care. I truly hope there are consequences for this one day. Okay, again, laying aside Julie Kelly's opinion, I would like to point out something. And I think this is a fair question to ask. If she's right, or maybe better to say, if she's accurate, and there is a window of about a year and let's say a few months between indictment and charges and the beginning of a trial for most everybody else related to January 6th, then I have a question. Why is Donald Trump being given defense before the trial starts? Oh, come on, man. He's the former president of the United States. He's the one that instigated January 6th. No. That would mean that the charges that are being brought against him somehow make it more appropriate to treat him unfairly before the law. Or maybe the proper legal phrase is unequal treatment before the law. Okay, the issues for which he's being accused are sort of irrelevant. Should he not be treated just like everybody else as it relates to January 6th? If everybody else is getting a year and some months between the filing of charges and the beginning of their trial, why is Donald Trump being given only 7 months? Why is Jack Smith so desperate to get this trial started by March that he is willing to bypass an appeals court and go directly to the Supreme Court and say, look, you guys have got to rule on this. You've got to lay down a judgment. I've got some suspicions, and again, I'll get to them here in just a minute. But let's go a little bit further. I want to show you some other stuff. This is also from the ruling. Let's see. Yes, here it is. As noted above, the district court has scheduled trial to begin March 4th, and the respondent has appealed. Given the uncertain timing of the appellate proceedings in the ordinary course, including potential requests for rehearing en banc, certiorari before judgment is appropriate now to allow the court to provide the prompt and definitive resolution that the issues presented here require. We've got to get an answer. We've got to get it on the record. What's going on? How are you going to rule? Is he going to be made to stand trial or not? And again, I'll go to something else. Mike Davis of the Article 3 Project. And he says the same thing that I just did. The defendant, not the government, has the constitutional right to a speedy and fair trial. The Justice Department waited 30 months to bring charges, and that's a very valid point. If this was so daggone important to the Justice Department, why didn't they file these charges long before now? Long before they did. They filed all this back in 2022. They could have filed this in 2021. And at that point, regardless of whether you support Donald Trump, think he's right legally or not, you really have no argument. Because trial would have been set probably to start in 2022. And honestly, this thing would probably be done and over with, and we might be in an appeals process depending on where it's ruled on. But instead, they wait 30 months, file the charges in late 2022, set a trial date for March of 2024, late 2023, set the trial date for March of 2024, and here we are. Now, others have also dropped their opinion on this, and I think they're worth reading. We go to the inestimable Jonathan Turley, constitutional scholar and teacher at George Washington University and Georgetown. Special counsel Jack Smith is now seeking to leapfrog the appellate court and ask for a ruling from the Supreme Court on Trump's immunity claims. The only reason for this petition is to seek to guarantee a trial of Trump and a possible conviction before the election. The matter is currently before the D.C. Circuit, which is viewed as favorable court to Smith. And that's a good point. That's a really good point. If the appellate court would rule in Jack Smith's favor anyway, why leapfrog them and go straight to the Supreme Court? I mean, look, if Turley's right, and the appellate court would probably rule in Smith's favor anyway, why are you in such a hurry to get this thing to the Supreme Court and get them to rule on it? But let's continue reading from his tweet. However, Smith is trying to avoid any delay in the March trial date set to begin before Super Tuesday. The Supreme Court may not view a trial of Trump during the campaign to be a motivating or urgent factor as Smith does. This is a novel legal argument that the court would ordinarily prefer to hear the views from the appellate judges. And again, that's a valid point as well, which we'll come back to. A few other things to mention. And now here's where we get into my opinion on this matter. I am inclined to believe, contrary to political protestation from people who might be watching this video, that indeed Jack Smith is absolutely desperate to get this trial started by March of 2024. He has to get this thing rolling. He has to try to get some kind of decision on Trump before the election. Oh, come on, he's a special prosecutor. He doesn't let politics enter into any of this. Really? You sure about that? Can I absolutely prove that he is? No, I can't absolutely prove it. But the man's actions cause me to want to believe what I believe. If it walks like a duck, quacks like a duck, and looks like a duck, it's duck. If a prosecutor is desperate to get a trial started before a general election in November 2024, is bypassing appellate courts to try and make that happen, and is arguing that the government is guaranteed the right to a speedy trial, not so much the defendant, then yeah, I'm pretty well convinced this guy is desperate to get this thing going because he wants to get a decision on Trump, preferably guilty. Now, that said, a few thoughts about what could happen at the Supreme Court. I think Turley brings up a valid consideration, and that's this. The Supreme Court, at least it's been my observation anyway, is not necessarily inclined to go bypassing an appellate court or bypassing the process of appeal. Usually they like to let a ruling sort of, shall we say, marinade. Maybe that's not the best way to describe it, but you get the idea. In other words, before it gets to them, they want to make sure this thing has gone through the ringer. In other words, district court, appellate court, then it gets to them. I don't know how favorably they're going to look upon the idea that Smith is trying to bypass the appellate court's ability to rule on this question and go straight to them, especially when we're rolling into a presidential election year. Now, a couple other thoughts on the matter. And these aren't necessarily original to me. I happened to be listening to Robert Barnes this evening, and he brought up a very valid point. Let's assume for a moment that the Supreme Court actually decides to take this up. Which, by the way, as opposed to needing 4 judges to do this, you have to have 5. 5 judges because you're bypassing the appellate court to go straight to them for them to issue a decision of writ. So let's assume for a moment the Supreme Court does take this up. Well, the next time that they're in chambers is going to be early January. And let's assume that 5 judges do decide to rule on this. Okay, just exactly how quickly can the court call upon the lawyers to file motions and make arguments? Well, okay, it's the Supreme Court of the United States. They could do it pretty quick. But would they be inclined to? I guess the question I'm asking is this. Let's assume Smith gets the court to say, yeah, we'll take the case. Well, if the trial's supposed to start at the beginning of March anyway, what's to stop the Supreme Court from taking until the beginning of March before they ever even rule on the question? In other words, there's no advantage to you to go to the Supreme Court. If they're going to take until February or March to rule on the question anyway, any advantage you might gain by appealing directly up to them is moot. It doesn't do you any good from a timing standpoint. The only way it would is if they ruled in February or late January, which, are they really inclined to do that? Especially considering that they've already got other cases on the docket anyway. I don't know. But there is one more point to consider, and this is something Barnes brought out. Let's assume for a moment, again, that the Supreme Court decides to take this thing up. Are you really sure you want the Supreme Court ruling on this? Because if they do decide to take this up, what's to stop them from saying, you know what, this whole thing is a load of bunkum. Presidential immunity applies. The case is dismissed. I think that's a fair question. Because that's exactly what Smith is asking them to do. Smith is asking them to decide directly on the question, does the President of the United States, Donald Trump, enjoy immunity because of his former office that he held and the fact that he is a former president? Does it grant him immunity? You're appealing straight to the Supreme Court, and you're asking them to rule directly on that question. As I said at the very beginning of this video, this is a high-risk legal maneuver, because if they do take this case and they rule that, yeah, immunity applies, all charges dismissed, Trump is innocent, he can go on his merry way, then everything you've been doing leading up to now is just down the drain by your own hand. So, ladies and gentlemen, we're going to keep an eye on this one. We'll see what happens. Like I say, it's high risk, high reward. If Smith pulls this off, we got a trial date that starts in March. On the other hand, Smith may have just sealed his own fate as far as getting this whole effort to get Trump convicted legally killed. But we'll see what happens. That's my thought on the matter. What do you think about it? As we start to wrap up this video, please do me some favors as always. Number 1, if you're not a subscriber to this channel, please do so. Number 2, please leave a comment below. I'd love to know what you think about all this. Number 3, please hit the bell for notifications. I would love to make sure that you're always aware when new material, be it a video or a live stream, is coming out. Number 4, share this video around. And finally, give me a thumbs up. My name is Brian Trippett. I am your Front Porch Conservative, and I'll see you next time.